What first inspired your interest in international law and policy?
It's a great question, and I've been trying to think of where it started. And I think it was because I was interested in environmental policy and environmental protection. And at some point in school, and I don't remember exactly what subject it was, we started talking about things like the UN Convention, the Framework Convention on Climate Change, and then the Kyoto Protocol, which is a treaty from 1997, so back when I was in school, that was meant to sort of have countries agree to emissions caps. And I remember long arguments with my dad about that. My dad loved arguing about these kinds of things. And, me being a young, idealistic, pro-environment kind of person, talking about the importance of all of those kind of things. And that's my first memory of really getting interested in some kind of international law, international agreement.
Were there moments during your PhD when your perspective on trade and environmental law shifted?
Yeah, so my PhD and a lot of my research before that looked at within the sort of trade and investment treaties and these economic agreements, there are exceptions clauses that sort of say you can have a government policy that impacts trade if it has a legitimate environmental purpose or if it's necessary for the protection of the environment. And I think when I first started looking at those, I sort of bought into the idea that you can draw a neat line between legitimate environmental policies and governments kind of claiming something's environmental, but it actually being protectionist or about economics or something, they claiming environmentalism when it's not. And I think for me, the biggest shift I had was looking more and more and saying, well, actually, most of the time governments don't regulate perfectly. They don't enact optimal regulations, whether that's an optimal environmental regulation or economic policy. There's always a political compromise, and there has to be room for governments to do things in a way that may not seem like the best course if you were thinking in an ideal world, what would you do, but is realistically what they can do.
So you worked a little bit in private practice. How did you navigate the move from that to The Hague?
So I did work in private practice here in Melbourne for a few years, and I think I worked at one of the big commercial firms, and going in, they knew full well I was a flight risk, I think. I remember at the end of my clerkship having an interview with my supervisor, and he was like, we think you're great. We're pretty sure you won't stay here for that long. But, if you want to stick around, we'd love to have you. And we were all on the same understanding that this was probably always something I wanted to do. For me, what I did when I left practice and I went immediately into a master's degree that I did at Columbia Uni in New York. And that was sort of the branching into both leaving the Australian legal space and kind of making more international networks and meeting other people, but also into academia, because there was no way I would get into academia without further education, without doing a master's and then a PhD. So that was kind of my starting point for that. And then I worked there for a year and then went into the PhD.
What was it like working there?
It was really great. I mean, it's very different. It would be very different now. The current climate in American universities is a whole other thing. But when I was there, American universities are really interesting. They have a lot of more resources than Australian universities. They have a lot. They're culturally quite different, not in a bad way, but there's a lot more sort of private, charitable kind of support and less government support, which changes in terms of research people do at universities. It can change the kind of research agendas and things. It means you do a lot more kind of time, at alumni lunches and meeting with people and networking and trying to get donor support. Whereas here in Australia, we spend a lot more time trying to get government support. So there's little differences like that.
Much government support in the US or not really?
There's some, but less.
Okay.
Right now it's different. Again, they've really slashed a lot of that in the current administration in the US, but there is some government funding for research, but more of it, especially in the fields I was in, came from philanthropy.
Would that have been family offices or just some wealthy donors? Or?
So some of it.
Okay.
So the centre I worked for at Columbia, which is a centre for climate change law, most of our support was from a wealthy family based in New York that, I think they made their money in steel and iron back in the 19th century. And then they were funding a climate change law centre.
Awesome.
Lovely people.
I understand you also worked in the US Claims Tribunal.
Yes.
What did you learn there?
I mean, the Iran-US Claims Tribunal is a very unusual little institution. It's based in The Hague in the Netherlands. It, as its name suggests, settles claims only between Iran and the US. No other countries are involved. It was set up after the Iranian Revolution to disentangle all sorts of legal disputes between both Iran and the US as countries, but also Iranian investors in America and American investors in Iran. because after the Iranian Revolution happened, the two countries had extremely close relations and then went to absolutely no relations, pretty much. And so this tribunal was set up in The Hague with a very specific mandate to sort of allow all the investors to bring their claims and then the countries. No one thought it would last more than a few years. It was set up in 1981. It is still running. And so I was there very late in its term. I was there in 2016, 2017. It's a really, it's an unusual place because of its very narrow focus. It has 9 judges. There's 3 American appointed, 3 Iranian appointed, and then 3 third countries. So they come from not America or Iran. I mean, when I was there, it had a very collegial attitude. Everyone got along very well. There's books written about its earlier history where that wasn't the case. There's a famous incident, apparently, of one judge punching another in a corridor in the early 1980s. A much fierier time. It wasn't like that when I was there. But it was a really it was just very interesting to see the way that two countries who so often had such sort of fractured relations with one another could constructively work in this institution over decades to slowly try and resolve what were really what still are very intractable and difficult legal problems.
Are there still a lot of claims or sort of matters still in proceeding? Or?
The number of cases that's left is very small. So, and they're only the state-to-state cases that are still there. All the investor stuff was dealt with decades ago. And the main case that's remaining to be resolved and what I worked on is a claim by Iran against America relating to before the revolution, Iran used to buy a lot of military supplies from America as part of the US's foreign military sales program. Obviously, America stopped selling them that after the revolution, unsurprising. And Iran is obviously claiming for sort of contracts that were unfilled, money that had been prepaid that needs to be returned, breach of contract, that kind of stuff, which all sounds very esoteric. But it is, in fact, a multi-billion-dollar claim relating to difficult issues around military stuff and kind of what happens with those contracts when a country so fundamentally shifts their regime of government from the previous sort of, monarchy with the Shah that was very pro-US to obviously a very anti-US regime, I think is a fair way to describe it. And so that is one case, but it's a behemoth in terms of the number of, it has about 1,300 subcases relating to specific contracts. The documents fill rooms. It's a big, complicated thing. And also it's difficult now. They're litigating it 45 years after the fact. Your witnesses are no longer around. It's, that in itself creates other problems.
Have these tribunals evidentiary rules, or sort of how do they govern that sort of aspect?
Yeah, there's evidentiary rules that they follow. And I mean, most international courts and tribunals, there's different, depending if it's an arbitration tribunal or if it's a court, it might have its own rules. The Iran-US Claims Tribunal has some sort of bespoke rules, but there's also fairly standard rules for things like evidence and pleadings and things. And the judges also just kind of decide what's reasonable in terms of timeframes in the circumstances. Both sides, the US largely has just its own lawyers from the State Department. Iran tends to engage commercial lawyers as well from international firms, as well as obviously having government lawyers there, and then barristers, often based out of London, come in for both sides as well. It's a very slow process. The case has been going for 40 years and I don't know when it'll end. So it hasn't been actively running for that whole 40 years. Obviously, that would be a crazy long trial. But they just sort of, sometimes international courts and tribunals also just make the procedures up as they go along as needed. And that sounds sort of unusual when you're used to domestic courts, but it's really just about making it work, if that makes sense.
I understand. And how many other tribunals are there like this in other countries?
There's really nothing else quite like the Iran-US Claims Tribunal. The model it has is based on some earlier tribunals and things called claims commissions that might have arisen out of a specific conflict to sort of settle claims after that, or a change of government, like a quite dramatic regime shift. But there's not many that have existed like this at different points, and there's certainly not many that operate now. The closest comparator would be some of the ad hoc international criminal tribunals, like that for Rwanda or the former Yugoslavia or in Cambodia, which were sort of ad hoc tribunals set up to adjudicate international law issues, but specific to one country or one situation. But they're doing international criminal law, which is quite a different kind of law. They're looking at actually, prosecuting people for violation of humanitarian norms, whereas the Iran-US Claims Tribunal is not dealing with that kind of thing at all. It's much more about monetary damages and compensation and untangling, who owns what property, things like that.
What motivated your transition from legal practice to academia?
Two things. So I always knew that I wanted to do international law. I was always interested in, I was a classic arts law student. I did a lot of modern history and international relations and knew that international law was an interest point, and there wasn't many areas to practice international law and be in Australia. So academia always had an appeal from that angle. There's more international legal practice in Australia now, and it is growing, but there wasn't a lot. So it gave me an avenue into working in that field. I also love teaching. And so I always thought that academia would be a nice kind of balance between nerdy legal research, which I enjoy, and teaching and doing, areas of law that I find interesting. And it has a lot of freedom. It's a real privilege in academia that we choose what we research, which is really nice, and not something you get in many other jobs.
Would you be able to explain the concept of weaponized trade in simple terms, and why it matters now?
Yeah, so I've been doing a little bit of research on this with some colleagues from UNSW and Wollongong University, which is where I used to work. And weaponized trade, it's a buzz term. I don't particularly like it as a term. My colleagues won't be upset by me saying that. None of us think it's a great term. But really what it means is where countries use trade tools, so things like tariffs, but instead of using them for an economic reason, which is what typically they're used for, they're using them to achieve some other kind of political outcome. So they're trying to use them as leverage in wider political or geopolitical kind of disputes. And I think it's become sort of more, some people might say it's become more common in the last few years. It's certainly more talked about, of the sort of use of trade as a kind of form of leverage in political disputes.
Where did the term come from? What's the sort of origin?
It's a great question. So there's some scholars who have written more generally about the idea of weaponization just becoming a wider buzz term in the last sort of 15 years or so. Of all different things are being claimed to have been weaponized. So I think it's just part of that trend. It's used widely in the media. Actually, the Australia media has used it more widely pretty much than other countries, and I think that has a lot to do with the trade disputes between Australia and China that were really prominent from about 2019 until 2023-ish. There was a lot of talk in the media then about weaponized trade, and it was typically phrased by the Australian media as China has weaponized trade in, wider political disputes with Australia. But I think it also has now, in most of the diplomacy and the government use, been replaced by the term economic coercion, which I think is actually easier to understand. It's a use of economic tools to coerce. But I think the weaponized trade is a very media-heavy term.
How do you see the relationship between national security and international trade evolving? Because I understand you've done a bit of research on this.
Yeah, and the weaponized trade research relates to that, and I've also got a project on that. It's really interesting that, for example, we had the World Trade Organization, which started operating in 1995. And for the first 20 years, no one ever really used one of the national security exceptions. No one tried to invoke one in a dispute until we got a dispute between Russia and the Ukraine relating to not the current escalation of violence since 2022, but before that, Russia was in Crimea, a specific region of Ukraine, and it related to that. And in that dispute, Russia invoked one of the security exceptions. It was the first time it had ever really been looked at. And I think since then, and also just more widely in political discourse, there's been an increased focus on the idea of economics as a security issue in themselves, of critical industries, critical minerals, critical resources being a joint kind of economic and security issue, and of a wider and wider area of the economy being viewed as security related. So for so long, national security was viewed very much in a military kind of a lens. It was about territorial integrity. It was about actual physical conflict and those kinds of issues. Now governments are conceiving of it so much more broadly to include things like infrastructure, telecommunications, power, water, as I've said, things like critical industries and minerals, domestic manufacturing capacity. And I think part of the long-term result of that, I mean, I don't know exactly what will happen in the future, but I think there's a bit of a boy who cried wolf situation. That for so long, countries didn't use national security as the justification for things. Now they're invoking it a lot. And there's a lot of rhetoric. Like when President Trump talks about a lot of his tariffs, the current ones this year, some of those are not, they're just straight up economic, and he's fairly straightforward about that. But some of them he very specifically links to national security issues. And we're seeing more and more of that. And then we see other countries developing things like ministries for economic security, which really blurs the lines between what is economic policy, what is national security. And I think the effect of this is it actually dilutes the significance that national security used to have as a concept. Mm-hmm. It used to be the kind of, oh, you've invoked security, we're not going to question that, a real kind of respect and deference around that. And I think now it's becoming so widely invoked and the term has been a bit diluted, it's actually going to have an interesting effect where it doesn't have the same significance it used to.
Do you think that's part of a trend of these norms being eroded slowly?
Definitely. And I think, right now, what we're seeing is both just a straight up ignoring of the rules. In the case of what the US is currently doing with tariffs and trade policy, it is they know it breaks the rules and they don't care. Mm-hmm. I think that's a fair characterization. I think President Trump may in fact agree with that characterization. I think he's fundamentally trying to reshape the system and doing that by just breaking the system. Mm-hmm. But as well as the written rules, there are those norms. Like you said, there were these sort of unspoken, just kind of, well, people just don't do that. And I think a lot of that has shifted. I think for me, as someone who started studying these things and working in the field in the early 2000s, that's when I started studying them, there was so much of a focus on the institutions and the rules as a legal system, and they were binding and people respected them. And we've really shifted out of that now to the rules as written not being as significant. It's more back to a focus on power and international relations through power, and I guess more of a realist kind of take on things in that sense of sort of, countries seeing what they can get away with, countries pushing what they can, and a lot less concern with, well, what do the institutions say? What do the rules say? A lot less kind of the buy-in to the institutions themselves mattering and us caring what those rules are. When I say us, not everyone, and countries like Australia are still very clear that we want to support the international institutions and rules, and we hope that they will weather the current sort of difficult situation. But I think it's fair to say that there's just been a real erosion of the kind of unspoken assumptions around the importance of those institutions and the value of them.
Do you think there can be a return to that in the future?
I'm an idealist and an optimist at heart, so I think there will be, but I don't think it'll be quick. And I think this is where these institutions came from in the first place. They came, really the mid-1990s in international law, whether that's economic law and things like trade, whether it's environment. The 1990s and the 2000s were really a peak of kind of building international agreements and institutions and consensus and buying into the idea of kind of multilateral governance and the value of institutions and what we often call the international rules-based order. And that came out of having had a previous period of time from World War II until about then of not having those clear institutions, of not having rules in a lot of these areas, and gradually states building that consensus. I think we're going to go back to, countries having alliances, agreements between small groups of like-minded countries, cooperation between those groups, a lot more competition, a lot more kind of economic policy driven by that competition. But gradually, I think we'll start to see the difficulties with that, and countries will eventually come back to some kind of wider global, or as we could say it as international lawyers, multilateral kind of system. But I don't think it's going to be a quick process.
Which of your publications do you feel has most influenced legal or policy debate?
An article that I published a couple of years ago in early 2023 with a colleague of mine, Associate Professor Josh Payne at the University of Bristol. We wrote an article about how you could design exceptions clauses for investment treaties around climate policy. And what I mean by that is that we have these treaties that protect foreign investors. There's thousands of them in the world, and they give investors the right to sue where they think that their protections have been breached. And we're seeing at the moment a trend of cases where fossil fuel related companies are using these treaties to challenge climate change policies. So in Australia, we have one case brought by a company owned by Clive Palmer. That's a whole other part of the story in itself. But where one of the things that his company is challenging is a decision in Queensland to refuse a permit for a coal mine on climate change grounds. The decision to refuse that permit was driven also by the Queensland Land Court, a decision there. We're seeing a similar case has just started against the UK. There's cases against Canada relating to things like natural gas projects, both onshore and offshore. There's other examples of these. That's just a few. of these kind of climate-related cases. And there's a potential for billions of dollars worth of damages to be awarded to these companies under these rules. So there's been a fairly wide debate about what to do about this. And Josh, my colleague, and I wrote this article sort of discussing in a bit of detail how you could design a clause that you could add to treaties that would just say you cannot use these to challenge climate change measures. And that piece of work has been certainly the thing I've written that's had the most attention, both from other scholars, but also from governments and international organisations. And that's been a really great experience for me, was getting to present that work to groups of countries and places like the OECD, the Organisation for Economic Cooperation and Development, which is an international organisation based in Paris that does a lot of work with governments about investment policy. We've presented it at conferences there and discussed it. Also APEC, the Asia Pacific Economic Cooperation Forum. And I don't think any of those governments will adopt our idea. But I mean, especially with the election of President Trump in the US, the whole landscape for any kind of change in this area has changed globally. That is what it is, but it's interesting to be part of those conversations. It's fun to be presenting these ideas, have governments push back on them and say, we don't think we need that, or we think we can do it a different way.
What's been the sort of main pushback?
The belief that they don't need it, which is a really interesting one, because we will sit there and say, but there's this case, and this case, and that case, and this threat. And they'll sort of say, those are all just kind of outliers.
Cases.
Yeah, they'll be like, Clive Palmer, he's a very unique individual. And we're like, yeah, okay, so there's reasons why that's an odd case because it's Clive Palmer. But we're like, but the broader principle could still apply in many other cases. And I think sometimes with government, and I understand this, and I have deep respect for these government representatives that we talk to. They're not ministers or sort of politicians. These are bureaucrats who have worked in these areas of their governments for years, and they have wide experience. But it's often hard to get governments to change policy without a really big imperative to do so. And so very often it's reactive to something quite significant rather than a proactive, let's head something off before it happens. So I think that's been the biggest pushback we've had from governments on it.
I think that's a broader issue of democracy, some would argue.
Yes, absolutely.
Has there been sort of any adoption?
There hasn't been any adoption yet. We've had some conversations with governments, and sadly these are the kind of things you can't talk about in that much detail in these kinds of but where they don't know that they're going to adopt our idea exactly, but there's talk of adapting it in different ways, taking inspiration from parts of it, and we'll see what comes out of that. Treaty making is an incredibly slow process at the best of times. And so this was work that, we only started talking about in 2023 and 2024. So we won't probably see anything. It would be great if we do see some influence on that. And I think the conversations are still having a wider influence. So we're sort of one piece of work suggesting something. A lot of countries think what we've suggested is perhaps too radical, but then we see some more moderate changes. So one thing we've seen some countries do is issue statements about how their existing treaties should be interpreted, saying, for example, that they might have a clause that says, countries are still allowed to take policies that are necessary to protect the environment, and they've issued statements saying, to clarify, this includes climate change action and things being done in accordance with, say, the Paris Agreement. So I'm not saying our work is the only thing that sparked that. Our work was feeding into a wider debate and a wider issue, of course. But I think for me as an academic, it's just been great to be part of those conversations. And you get a lot of pushback. And that's part of the fun of academia in some ways, is there is debate about ideas and there should be debate about ideas, and you get challenged on things, and sometimes your own thinking develops. And that's great.
How would you respond to views on international trade becoming too complex and there being too many treaties, too many rules, regulations?
That's a very fair point. And the treaties are not, the international trade agreements, those treaties they're not easy things to understand. There's widely overlapping treaties. And for a country like Australia, and we've had a policy, policy might be too strong of a word, but we've really focused in our treaty making on the Asia Pacific region for the last 20 years, which makes complete sense in a range of levels. I'm not criticising that in the slightest. But it does mean that we then have relations with certain countries where we have 3 or 4 overlapping treaties. And that does make it quite tricky. I know that the Australian government, the relevant government departments, particularly our Department of Foreign Affairs and Trade, and within there we've got Austrade, which is our trade promotion agency. They do a lot of work with Australian businesses to try and create clear information so they can know, here's the lower tariff rates we've negotiated here, or the better quota for this product, and to try to help them figure out where the new market opportunities are and what the best. But it is complex, and it does create a very difficult web of rules. I don't necessarily think that is a huge problem in itself, but it's not ideal. I think in an ideal world, you'd have one clear set of rules with each country, and also you'd have more consistency between the rules. It is an unusual, our rules with Thailand are slightly different to our rules with Singapore, to our rules with the US. That's also hard for business to navigate. And I think businesses would like a lot more standardization.
And is there any appetite for standardization or simplification?
It does happen. And I think, for example, in the Asia Pacific, we saw it in two big regional treaties that have happened in the last decade. So we have the Comprehensive and Progressive Agreement on Trans-Pacific Partnership, or CPTPP. We love an acronym in trade law. And it was driven, in part, negotiations were driven by the US under President Barack Obama, and then when President Trump was elected, he actually withdrew the US from the treaty. So but the other countries are still part of the treaty, and that involves Australia, Canada, some South American countries, and a few around Asia as well. And it consolidates and it doesn't necessarily replace all of our previous agreements, but it creates a kind of newer set of rules, and in that way standardizes and kind of brings some things up to speed. And then the other big regional initiative that was driven by China, so you could see there was a bit of competition here, it's called the RCEP, the Regional Comprehensive Economic Partnership Agreement. And it doesn't have quite as much of a standardization function, but it does have a little bit of that. And it involves a lot of the countries around Southeast Asia. India was in the negotiations but backed out. But then it's got China, Australia, New Zealand, and some other countries in it as well. So you see some pushes to kind of create these sort of wider regional treaties that do create a bit more standardization. But then you don't have the whole region in either. You have countries like Australia that are in both, and perhaps it just actually makes it all more confused.
And if you could give one piece of advice to a student entering this field, what would that be?
It's a difficult field to enter in sort of international trade law or international investment law. And when I say it's a difficult field to enter, I just mean most people don't start their career there. The one exception to that would be if you go, say, into the graduate program of a government department in the area, so the Department of Foreign Affairs and Trade, DFAT, you might end up, but even in DFAT, people are strongly encouraged to move around into different departments and do different things. So it's not necessarily something that you start in and you do the whole way through. Most of my friends who do it in private legal practice in big firms, a lot of them aren't in Australia necessarily, although there are some lawyers here doing it, but they didn't tend to start there. And so I think it's really important to think more generally about the skills that you're building, even if it's not specific to the field. If you want to be a lawyer who works on investment disputes, build your litigation skills. Work in litigation, build that experience, managing cases in courts, dealing with pleadings and documents and evidence. Those are the skills that will be really valuable when you then want to move into this specific kind of dispute. Similarly, if you want to go into government and do that kind of work from a government point of view in, like, say, treaty negotiation, working in government and government policy is its own skill set, and getting experience in that is important. I think people often see a job that they want and it's in a specific area of law and they think they have to have expertise in that area of law. That isn't bad at all, of course, but often the hiring will be more about general skills. Yeah.
And do you have any broader pieces of advice beyond the field?
Yeah, I mean, well, look, I think one of the really significant things about people who are entering the workforce now, and it was true for my generation, it's even truer for the generations entering the workforce now, are you don't know what you're going to end up doing for most of your career. I don't know what I'm going to end up doing for the rest of my career. And I've gone on all sorts of paths that I did not anticipate up to this point. If I could wind back 20 years and tell the Liz who was starting university that I would become an international trade and investment lawyer, I would have said you were insane. It's like, there's a reason I didn't study commerce. I don't understand that stuff. This was an unexpected path for me. And there's been all sorts of odd, unexpected turns along the way. I think being open to those is really important. I think so often the things that end up being great experiences are not what you expected. And I think because we don't know, because most people don't really know how their career will evolve and there's a lot of change, that people are seeing now in their careers, and that, you know, people are changing not just firm or job, but like fundamentally might change career a few times. I think focusing on the general skills is really important. I think so many students focus on things like getting good grades or what do they need to do to be a good lawyer, which is important, but think even more broadly than that. Like, one of the main skills out of a law degree is critical thinking. It's advocacy. It's forming an argument. It's learning how to be persuasive. Keeping your eye on those big picture skills that can be redeployed in a whole range of different areas.
And what do you think the next decade of international economic law will look like?
Chaos is my short answer to that. The short term, I think, is chaos. When I started entering academia and doing my PhD and things, and I go to conferences about international law broadly, and there's, you know, the humanitarian lawyers who deal with the laws of war and crimes against humanity and things. And then there's your human rights lawyers and environmental lawyers, which I do some environmental trade and investment, different branches. And the thing that we used to have in international trade and investment law was I was like, oh, we have such functional dispute settlement. It's so much like a legal system. There's hundreds of cases and things operate not on a formal doctrine of precedent, but a little bit like that. And I was like, oh, it's so, you know, there's enforceability, and all of that has fallen away in the last decade, in the last 5 years or so, really. And it's just a very different kind of system to what it was. And I think we're entering a phase of, a lot less focus on law and institution, a lot more focus on power and politics.
Thank you, Liz. I really appreciate it.
No worries.